everybody, and welcome to another episode of LJ Law, Family Law TV. I am Bonnie Leonardo, your host. Today's question comes from Andrea, and she listed this question on our Facebook. The question is, what can unmarried couples living separately who cannot agree as to which parent should have guardianship over their disabled minor child do? Before I get started with that question, I want to remind you that if you have questions about this topic or any other family law topic, please don't hesitate and go to vegasdivorcemeeting.com. I'll be more than happy to sit down with you to discuss your particular situation. So, once again, to the question posted by Andrea, unmarried couples living separately who have a child who is disabled, and they cannot come to an agreement as to who should have guardianship of this child. So because these parents cannot come to an agreement as to who shall be the guardian, then one or both parents must petition the court in the proper county and request that the court appoint a guardian. Now, the court does not take guardianship decisions lightly, and so most often it will require expert testimony from psychologists, from physicians, from social workers, before making a decision. And the court does this because it wants to be sure that the final decision regarding guardianship of this child is in the child's best interest. Now keep in mind that the court may not approve guardianship for a parent who has had issues with substance abuse problems, has committed a felony, or has had history of abuse, neglect, or abandonment of a child. The guardianship cases normally take between 2 to 3 months to complete, and they may be costly due to the fact that we're using expert testimony. In the end, the court may appoint one parent as a guardian, both parents as co-guardians, or in a very rare situation where the parents cannot agree and it is a very contested case and the parents have the inability to communicate and an inability to co-parent, the court may appoint an independent guardian. So neither parent will be a guardian, will have a third-party independent person appointed as a guardian. For these reasons, it may be beneficial for the parents to sit down and discuss this amongst themselves to try to come to an agreement as to guardianship. Maybe share the time. Maybe one parent is better suited to handle this child's needs full-time, and the other parent can be there part-time. Whatever decision is best for your situation, my recommendation is always try to come to an agreement before you put your future in the judge's hands. The judge does not understand your family dynamics as much as you do. I hope that I have answered this question for you, Andrea, and anybody else who has the same issue. If you like the video, please hit the like button. If you know someone who can benefit from this information, please don't hesitate and share this with them. And as always, I would like to thank you for tuning in, and I will see you next time.